Got it.
Good work. We're frozen.
Time is a charm. It'll eventually make your life.
Hey, how's it going? I'm Chris Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today we've had some write-in requests asking us questions about the time frame in which to probate a will and a failure to probate a will within those time frames. Kristen, kind of what are we talking about?
Sure. So the general rule is you have 4 years to probate a will after someone passes away. So that's the rule that you should learn. That's the rule that you should adhere by. If a loved one passes away, you should go visit an attorney within that 4-year period, talk to them about probating the will, because that is just the general rule that exists. If you don't probate a will within 4 years, it's considered to have not existed. That's the presumption that Texas law gives. So if you have not correctly probated it within 4 years, then you should assume that you're out of luck.
Yeah, and so when we say probate the will, that's, of course, the legal process where the original will is presented to a court or a copy, and you have to do all the jumping through hoops required there. And the person doing the presenting, generally speaking, should be the named executor, right? That's their duty to get that will before court. And so, of course, sometimes people, life is hard. Sometimes people get busy. Sometimes people forget and can run into trouble. So showing up at 3 years and 9/10 almost over is not an ideal situation, and sometimes people miss it. So what are the consequences? Let's say we missed it. Is it over?
Sure. So I believe the question was geared towards, are there some exceptions? And there are. Again, though, we want the message to be, you need to go see a lawyer. You need to probate it within 4 years because you are subject to the rule, not the exception. Could you fall within the exception? Maybe. So we'll talk about what those are. And I actually want to just read you the rule, which is in the Texas Estates Code 256-003, except as to a foreign will, a will may not be admitted to probate after the 4th anniversary of the testator's death, that's the individual that passed, unless it is shown by proof that the applicant for the probate of the will was not in default in failing to present the will for probate on or before the 4th anniversary of the testator's death. So what was easy for you to do within 4 years if you had a valid will, to present it and the court would admit it as long as it's a valid will and all of those validities are checked. After the 4th year, now the burden has shifted to you to show why you're not in default and that will should be admitted to probate. So not good advice, but is there an exception? Yes, there is. So let's talk about that just a little bit more, Chris. So let's say I have not probated the will. How do I show that I'm not in default in failing to present the will before the 4th anniversary?
Yeah, I've had a couple situations in the past. Of course, the court will ultimately make decisions on this as part of your application when you file it. Some of my people who filed, some of my clients who filed, were not the named executors. They were backup executors, and that most of them didn't even know there was a will until, dad passes away, leaving everything to mom. Mom's the named executor. Mom doesn't do anything. The kids have no idea there was a will, where the will is. Mom then passes away. The kids then find dad's will and say, oh, I'm the backup executor. This will needs to be probated. Why didn't mom do that? Well, in that case, if you're not the named executor, you're probably not in default for not probating it within the time period. Sometimes those wills aren't located within 4 years. I have hoarder situations. I have single individuals, or families are distant. But these are fact issues that have to be decided. So not a comfortable situation when a client comes to me and says, hey, what's the future look like? And I have to say, cloudy.
Yeah.
I don't know.
We don't know.
I mean, we think, we hope, but that's not a guarantee.
It is very court specific. An attorney really could not guarantee you that it will end well for you. There is a number of cases that are fact specific where different courts decided different things. I've personally had several where I was able to prove to the court that the individual just didn't realize. They assumed that the will was already transferring title specifically to a house, although I will say that in general, ignorance of the law is not going to be a good reason or in good faith. And so I think that's a little unusual and lucky for the applicant in that scenario. But it would be very fact specific. The other thing that we want to talk about is how that process would work. Typically in Texas, the rule goes on to say that a letters testamentary, which is the appointment of an executor, may not be issued if a will is admitted to probate after the 4th anniversary. Typically, when people are probating a will to transfer title after someone's been dead for 4 years, they are only able to do that as a muniment of title, which is where the court says, okay, this is a valid will. You have good cause that you weren't negligent in, that's not the word, not negligent. You were not in default by failing to present it within 4 years. They admit the will to probate, but they will not appoint an executor after that 4-year time period. So that's typically done as what's called a muniment of title. So the executor is not appointed, but the court admits it into probate for the purpose of transferring title, often to real property, sometimes to titled things like cars, but usually people figure those things out within 4 years. What, Chris, are some additional requirements that we would have to do if we were going through the process of admitting a will, typically through a muniment of title, after 4 years?
Yeah, so the added complications you're for sure going to run into is that the court is going to require that the heirs, the natural heirs, the intestate heirs under Texas law receive notice. So this can be very complicated in a blended family. Husband has passed away, surviving spouse has waited more than 4 years. Maybe she doesn't have a close relationship with those kids he had 30 years ago. Maybe she doesn't know where they are. Maybe those children, upon receiving notice, object. I mean, things can get complicated, but you have to find the natural heirs. What if one of those natural heirs' children has predeceased but there's grandchildren? I mean, things get complicated. If they're minors, as you can imagine, the longer these go, the harder or more complicated they get. Every natural heir is required to receive notice or have waived notice, and the courts will enforce that. And then now they're all interested. Oh, well, maybe I do have a dog in this fight. They definitely have a voice in that hearing, which, as the applicant, you are not going to want to hear.
Yeah, that is the most common scenario that I think we run into. A second marriage will from a spouse leaves everything to the surviving spouse but doesn't get probated. Well, then the surviving spouse comes after 4 years to probate that as a muniment of title. You will have to give notice to the heirs of the person that died, which would be their biological or legally adopted kids. One other scenario where that would occur is if there were 4 kids, but the will left the property just to 1 kid. Yeah. If you probated that will after 4 years, you have to give notice to all the intestacy heirs, which would be all 4 of the kids. Specifically, what the notice requires, too, is is not ideal, and that's found in Section 258.051. The notice to any heirs that must be notified contain a statement that the testator's property will pass to them if the will is not admitted to probate, and that the person offering the will for probate may not be in default for failing to present it within that 4-year time and then given a copy of the will. So if I'm that surviving spouse, I have to send my husband's biological kids notice that I haven't filed it within 4 years, so I may be in default. Notice that if I don't get it admitted to probate, that they are the heirs at law and will receive the property, and then the opportunity to come contest a copy of the will that I've had to give them. So not ideal. Of course, if everybody gets along, great. They're allowed to sign a waiver saying they support the admitting of the will, and all can be fine. But you do have to prove to the court that you've given them notice, and that notice has some strong language that if you have no relationship with them, you can't really guarantee how it will end.
Yeah, you'd be asking them to give up a windfall, is basically what that would say. So
right. So is it possible? Yes. Is it guaranteed? No. Yeah. One other thing we wanted to mention, which is one other exception. So typically, if you're probating a will after 4 years, you would be doing it as a muniment of title with the additional burden of showing that you're not in default and that you've noticed all of the intestacy heirs. So not ideal. Again, go with the rule, not the exception. But one other thing that can happen in a very unique situation is that the court can appoint, this is another exception under 301.002, the court can appoint an administrator for an estate, which can be heirship, no will, or a will, if the administration is necessary to receive or recover property due to a decedent's estate. So there is an exception for getting an administrator, not an executor, but an administrator appointed to handle the affairs of the estate if it's been after 4 years, if there is property to recover into the estate. So I've used that honestly only one time, which was when there was some oil and gas property or proceeds that had been given to the unclaimed property in a certain state. It was over $200,000. We were able to appoint an administrator to go claim the proceeds that were due to the estate. But I've only been able to use it in that very limited situation, and so wouldn't consider that to be a broad one, but it is there.
Yeah, the more and more I do these, I'll just be honest. I always recommend, as a global rule for most people, most of the time, if you are the beneficiary of a will, you should strongly consider probating it. It's easy for us to say that because we're probate attorneys, but I've just seen so many problems where people later wish they had. Later acquired assets, civil lawsuits have showed up, proceeds, unintended consequence of inheritances from distant relatives. It goes on and on. If you're the beneficiary of the will, if you're the recipient of the will, you should strongly, strongly, strongly consider having that will probated, even if the immediate benefit isn't clear.
Sure. And the downside really is just you're out the attorney's fees and the time going through it. There's no downside except for that you have to pay to probate.
Yeah, the more I see, the more I just become probate the will. So,
sure.
Anyway.
Anyway, the message is probate the will within 4 years, but there are some exceptions. So if you find yourself in a situation where you have a will that has not been probated within 4 years, do go get the legal advice on what exception might apply to you. But as a general rule, when someone dies, go probate their will.
Yep. Great question. If you guys have any other really good ones, go ahead and send us a message and we'll read over it. But we thought that was a good one.
Good question. Happy to answer it. Bye, guys.